So this is the third of 6 sessions in my estate planning boot camp for financial advisors, insurance agents, CPAs, and others who I work with in teams to assist our estate planning clients. Thank you. I'm very grateful that you all made the trek here this morning to be here so early on such a winter's day, it looks like, you know. But hopefully the sun will come out while we're speaking, and maybe you'll be illuminated in many different ways on how we can work together and how you can assist your clients on estate planning. And that's really what this is all about. Today's special focus, we have 2 parts to the session. The main part is dealing with comprehensive estate planning for IRAs and retirement plans. I'll do a rehash of a little bit of what we talked about in sessions 1 and 2 very briefly, and then we'll jump into the IRAs and retirement plans. And I know you're going to have questions. If you do, please raise your hand, and I'll repeat the question, and then we'll try to answer it as best we can, if we can. If we can't, then we'll defer it to another time and see if I can get you an answer by email or by telephone, okay? Let's get going. So, to reiterate what we talked about in the last couple of sessions, estate planning is planning for yourself, it's planning for your family, it's passing the assets the way you want to and building a legacy that you want to pass on. And the typical definition of what is included in your estate, it's real estate, it's cash, it's investments, it's insurance, and the like. It's your personal property, and of course it's your IRAs and your retirement accounts, which again we'll focus on. But it's really broader than that. It's not just your property. It's planning for your family, planning for you if you become incapacitated, and really planning a legacy that you want to leave behind, which is a lot more of what I've been doing over the last 15 years of my 35 years in practice. So the idea is trying to articulate what your values are for estate planning purposes and building them into the documents so that you're passing that on to future generations or for charitable purposes for that matter. Who's the team? Well, this is all in your packet, by the way, so there's a handout. You can follow along in the slides if you'd like. But the team is the financial advisor, which may include multiple people on the team. There may be an insurance agent who's separate from the financial advisor. And everybody has a distinct function. CPA is going to be involved in preparing taxes and tax planning, primarily. The insurance person is going to be helping in financial planning and life planning with insurance. The financial advisor is going to be providing guidance, certified financial planners or financial planning, as well as managing investments. We want all of you to have access to this. And then the estate planning lawyer may or may not be the quarterback. The estate planning lawyer works with all of you either to help quarterback it, help design the plan. Sometimes the financial planner designs the plan. Sometimes the estate planner does. But we should all work together in a coordinated fashion to make sure that the plan is carried out for the client. How many of you have a will or a trust currently? Don't be embarrassed if you don't. Okay, so if you don't, you still have an estate plan. Did you know that? Why? What? The government will tell you how things will pass. Virginia has its own rules. In Virginia, if you have a spouse and you have descendants, that includes children and grandchildren, and at least one of those comes from somebody other than the spouse. Did you know that the spouse only inherits 1/3 of the intestate estate? What is intestate? Intestate is what passes other than by beneficiary designation or by operation of law. So if you own something jointly with survivorship rights, that passes by operation of law. It doesn't pass under intestate law or by will. And so the intestate estate is that which passes other than by operation of law or by beneficiary designation. In Maryland, it's a totally different set of rules. So if you have a spouse and a kid who is a minor, Maryland law says, under intestate law, the spouse inherits 1/2 of the intestate property, and the children inherit everything else. That's different from Virginia. And is that what you want for your kids? In DC, it's another set of rules. We're not here to study all these rules or to memorize them. What you're here to know is that every state has a different set of rules. And therefore, intestacy is not the way you want to go. So if you don't have a will, get one. If you don't have a revocable trust, get one. Because we don't want to be left to the vagaries of state intestacy law. So plan ahead. Have your clients plan ahead. This is an important function that you serve for all of your clients. And try to help them leave the legacy. We can help with that. We know what wills are. We've covered this. Multiple sessions. We know what they do and what they don't do. What do wills not do? What does a will not do? Say?
Avoid probate.
Will does not avoid probate. What's probate? Probate is the process that you have to go through if you have an asset in your own name and it doesn't pass by beneficiary designation or by rights of survivorship. It has to go through a court administrative process, which is public in Maryland, DC, and Virginia, and all the other states. It's a public, court-driven process. Virginia is very specific about the rules regarding probate. You have to file inventories and accountings. It's costly. You have to pay the commissioner of accounts a fee to audit, and there may be a probate tax. Maryland is a little less rigorous, but it's still a pain. Lawyers have to file a petition to get paid out of the estate, and they charge the estate to file the petition. It doesn't make any sense. Maryland has got inheritance tax, and it's got other issues. And then DC, even if they have unsupervised probate in DC, which they do have, don't go through probate in Washington, D.C. We handle many of them here. Washington, D.C. is a third world country. I'm serious. It's very difficult to get anything through the Register of Wills in the district, even if it's a simple filing. And they all have different views of what the law is. We've had different people in the Register of Wills give us different answers to the same question. So if we want to take advantage of a will, everybody should have a will. Most importantly, it nominates guardians for minor children. It names an executor of the estate. But if you're incapacitated, what a will also does not do is handle your affairs in the event of your incapacity. So if you are unable to act for yourself, at a minimum, you need a durable power of attorney. Now, durable powers of attorney can spring into existence upon your incapacity, or they may be immediately in effect. A springing power of attorney is not valid in the state of Florida. So what do if you don't want to appoint somebody immediately in Florida? And some states are like this. It's a morass of different laws. What I'm leading to is, if you have property of any kind, and you want to make sure that it's handled during your lifetime in the event of your incapacity or upon your death, what should you do? What should you have? For those of you who came to the first two sessions, what document should you have in place other than a power of attorney? Come on. Healthcare power is important. We'll get to that. Revocable living trust. Everybody should have it. Not just somebody who's got $5–10 million of assets or $2 million of assets. Everyone should have it. Because if you're incapacitated and you have your real estate in your revocable living trust, then your trustee, your family, will not have to go to court to get access to the property to do what you need to do. If it's not in the trust, even a power of attorney will not work. The title companies will not accept a general durable power of attorney for real estate. It's got to be a specific, limited power for a specific transaction. That's all title companies in the Washington, D.C. metro area. So again, revocable trusts is where I'm leading. Healthcare power of attorney is part of your estate plan. It designates someone to make decisions for you in the event you're unable to make them for yourself regarding your health care. It allows them to receive information about you and give information about you. And it also includes a HIPAA release, but we do a separate HIPAA release here. So we have 3 medical documents: the healthcare power of attorney, the HIPAA release, and a living will. The living will is not a will. The living will is a document, also known as an advanced medical directive, that allows you to make decisions regarding what happens to you if you're terminally ill and death is imminent. Not just a matter of weeks or months, but a matter of days or hours. Do you want to have hydration intubated, provided to you if you're in this condition and can't make decisions for yourself? Do you want to have nutrition? Terry Schiavo, always think of the Terry Schiavo case. That's what the issue was in that case. If none of those, do you want to do everything to keep yourself alive? That's sort of the opposite extreme. How long do you want to be kept alive if you're in this state? These are tough decisions. Very difficult for us to talk about it with our clients, but we have to do it.
I have a question regarding setting up a revocable living trust.
Yes.
Do you then have to retitle everything that goes in there?
So, a living trust, do you have to retitle assets to go into the trust? And generally the answer is yes. You have to retitle accounts. You may have to change beneficiary designations. We're going to talk about that in terms of IRAs and retirement plans in a minute. And so that's the hassle
from the
of doing a living trust.
So
the house, we prepare a deed and move it into the living trust. In Virginia and Maryland, there's a statute that says if you're a husband and wife and you own an asset, a house, as tenancy by the entireties, it's a special property designation under Maryland, DC, and Virginia law. But in Maryland and Virginia, we have a special statute that says if you own that property, it's T by E, is the way we refer to it, and you split it, put it into a revocable living trust, 2 trusts 50-50 or 1 joint trust, it retains the asset protection that you enjoyed as husband and wife. What does that mean? So if I go to a bar and I punch somebody out in that bar and they sue me for $10 million and my insurance policy is not enough to cover me for that tort of battery, what do I do? Well, if my house is owned with my wife as tenancy by the entireties, or in my 2 trusts as tenancy by the entireties, and they sue me, they can't get the house. There is asset protection benefit of doing it that way. And still, you have the ability to deal with the house for incapacity purposes. Question?
And that's the same thing with a brokerage account.
Same thing with a brokerage account.
If it was
In
T by E,
Virginia.
and then you, okay. All
Any
right.
property that is T by E in Virginia, or anywhere else if you're a Virginia resident, has that same statutory protection. So living trusts are really important in your planning. It allows you to pass your property without going through the public, costly process of probate. It allows you to plan for incapacity, and it allows you to do other stuff like planning for your spouse, planning for your beneficiaries and your kids. And we've covered this in the prior 2 sessions. The first session is up on the web now under blueprintforwealth.org, and you can go and revisit those sessions. They're in 6 separate segments because they're so long, about 10 or 12 minutes each, if you want to go back and listen to it, or direct your clients to it if they want to get a little bit of education on that as well.